person with many international affiliations, too numerous for me to mention. I would take up too much of his time. But he is a person with strong affiliations now to Oxford, but also in Chile and Mexico, where he is currently practicing before the Supreme Court of that country. But most relevant to this evening, he's an international expert who has been a permanent advisor to the United Nations in the field of children's rights. He's particularly concerned with attempting to devise and implement international guidelines to safeguard children. And that's a topic, I think, which needs no justification in terms of its importance. So without further ado, I would like to introduce him to speak to us on the topic of child safeguarding and human rights towards a polycentric approach for public and private organizations. Nico is going to speak for 35, 40 minutes, and then we're going to take questions, whether from people gathered here in the auditorium or from people online who are dialed in on Teams. And if you put questions into the chat, we'll be able to see them. And also, once Nico has finished his presentation, you'll be able to use the raise hands function in order to get some attention. But Nico, it's a delight to have you as a very active intellectual and social member, if I can say, of our community, to hear you on this very important subject on which you are an acknowledged international expert. Over to you.
Thanks very much, Rick. It's a pleasure for me to be here today and to share with you some thoughts and reflections on a very demanding and I would say rather new field of child law that has not had that many academic attention as I think it should have for its ramifications and implications for international human rights law. So what I'll do today is to, and I'll show you a little bit the structure of my presentation. It's do this. So I'll do three things. I'll try to do three things. First of all, to show what is the importance of safeguarding when it comes to saving and protecting children from the risks of being harmed and abused. What are the interactions that take place when children relate with organizations in different areas and fields? What are the implications of those interactions? Some might be positive, but others might be not positive. Actually, could comprise violations of their rights. Secondly, I'd like to look at some emerging practices in the field of child safeguarding. This was part of a research I did for the United Nations, and actually was quite challenging because there are no ways to compare the ways in which these practices, standards, and law are created. And this is emerging in different specific areas of the law, and also from public and private organizations. So I want to look a little bit about how you have, on one side, some legal standards emerging in the field of child safeguarding, but you also have self-regulatory practices in the field of safeguarding for private, non-for-profit organizations, but also for businesses and companies. And thirdly, I'd like to relate what I've been saying with which are the state's obligations which have a direct connection with the field of child safeguarding, but also how to understand which are the responsibilities that the private actors have in the field of child safeguarding, and if this should be or not considered solely from a self-regulatory perspective, or if this should be at the same time conceived coming from specific obligations as set forth in international human rights law. So first, this idea of risk and organizations, how to understand safeguarding. So the first thing is that the children might be at risk of being harmed or abused in the context of their interactions with organizations, and this could be manifested in several ways. When performing sport activities or in the context of the international migration, when they're into contact with migration officers, they might be deprived of liberty, separated from their families, and this is done by an official that decides to do this, or retained in certain facilities where they have been separated from their families. Children also experience repeated face-to-face bullying at school, and this puts a pressure on schools, for example, to have and to create mechanisms to prevent bullying, cyberbullying, and other forms of violence that take place within the schools for all children, but for some children in particular. For example, LGBTIQ children who suffer from specific forms of bullying or violence. But also, while all children experience challenges, for example, when it comes to interactions with internet, online interactions, and they could be subject to, for example, travel and sex tourism, there are some children that experience more specific forms of risk when it comes to their interactions with organizations. Some children and adolescents are particularly exposed to the risk of being harmed by organizations and being left insufficiently protected by child protection systems. For example, girls may be especially vulnerable and at risk from certain forms of institutional violence, from the police, for example, or detention centers, including all forms of sexual and gender-based violence. Selling or leasing land to investors can deprive local populations to access to natural resources linked to their subsistence and cultural heritage. And the rights of indigenous children may be particularly at risk in this context. Investments, for example, to build railroads or highways or infrastructure. These are financed by companies, and these companies hire personnel, and this personnel may engage in child exploitation or other forms of violence within those communities. So you might be investing, development bank might be giving money, or a cooperation agency might be giving money to build schools, but in the process of building those schools, child sexual abuse might take place by the very enterprises that received the money that was originally given to for development, for actually protecting rights such as the right to education. So there are very many ways in which, sadly, their relations with organizations might become problematic, and we need to anticipate those possibilities. And this is the purpose of child safeguarding. As you can see, as one of the key definitions that we have is a responsibility that organizations have to make sure that their staff, operations, and programs do not harm children, and that is that they don't expose children to the risk of harm and abuse, not harm, but the risk of harm and abuse, and that any concern the organization has about children's safety within the communities in which they work are reported to the appropriate authorities. This is the strict definition of child safeguarding. You see, for example, some developments around the world, for example, Australia in particular, I think they have a more expansive understanding of safeguarding, meaning it's not only preventing harm, but trying to get the best outcomes from children when institutions interact with them, which I think is the right way to conceive child safeguarding. It's obvious that you don't have to harm children, but the idea is that your interactions are positive, are expansive of the powers and rights of children. So there are some principles. I will not go in detail on these principles. I can share some literature or documents with you if you are interested later on. But basically, the key components to understand child safeguarding is that it has to be, all children need to be protected from the risk of being harmed. All children, not just some children. And this push us to pay attention to some specific, more vulnerable groups of children, as I mentioned before. The idea that everybody has responsibilities when it comes to their interactions with children. It's not only state officials that have obligations, but we all have obligations when we interact, and we need to be more precise to understand which specific sort of responsibilities and obligations emerge in this field. I will get back to this later on. Integration, and this is a key component. The idea is that safeguarding is part of the whole way to conceive the organization. So it's not just a focal point that is like has the bad luck of being appointed the safeguarding official in an institution. And this happens a lot. It's like, okay, somebody has to take care of safeguarding. And that's not the way to conceive it. This means that when you are planning the activities of your organization, when you are monitoring what you do, when you have reports of performance, when you look at due diligence, etc., safeguarding is part of one of the core components of your organization. So it's not only respond to some allegations that might have an impact on the security or the integrity of children. Care, the idea that we all have a duty to care for children when they interact with them directly or through someone else that, for example, when we outsource a service. And this is quite important, especially for states. Various interactions have been, today, are outsourced to private actors. They are not executed directly by the state. Education, health, security, even in some cases. And this takes us to the idea that all actors need to be governed by this idea of duty of care. Helping partners, when you are engaging with others, you need to pass information to them. I was yesterday in a conference, on the World Conference on Access to Justice with Children, and when you start the panel, you read the safeguarding guidelines that you have in front of you. You are told that you have to be careful in what you're going to say, the words you're going to use, because children might be connected to internet while you are talking. So you are refrained from using offensive expressions. You need to be aware that you are interacting with children, even if I'm just talking to some colleagues in a conference where I don't think that this might have an impact on children, but children might be connected. Children might be connected to this conference. So I need to be aware about this, and we all need to be aware that we are interacting de facto with children. This is the embeddedness, how to understand this. Government's regulations, what I want to say by this, very rapidly, it's a fantastic, there are fantastic news that corporations, companies, TikTok, YouTube, or other companies are having their community rules. So meaning that they are trying to conceive how they interact with children. But it's not that they might do it or might not do it. It's that governments need to comply with their obligations to respect, protect, and fulfill the rights of children. And this requires to have normative settings within which organizations might develop innovative procedures and standards for child safeguarding. But this cannot be voluntarily, this is my point. And this is actually not solely voluntarily, and I will get back to this later on. Best interest at the core of thinking about safeguarding, information and participation. It's different to say, we take care of you, don't worry, we will not harm you, than when you engage with children to try to understand where there might be problems, how they perceive their security when they're interacting with the organization. A lot of institutions that struggle with this have protocols, so they know what to do when something happens, but they don't ask children how they feel when they interact with personnel, staff, or other members of the organization. This is key to really understand how they feel in terms of their security and welfare. And the idea to engage families and communities when you are working with child safeguarding standards, that the families, for example, are aware about those standards, know how to call them into action when it is necessary. Standards will just, you just have a general idea, but there are several standards that are more specific when you want to draft a child safeguarding policy. And there are many guidance on this. I will not go into detail, but I guess that you, first of all, need to have a policy, a formal child safeguarding policy. You have to design it, you have to think it through, you have to start from an analysis which are the gaps in terms of protecting children in your interactions. So you need to think the way you are, the way you interact, and the impact of your actions. And this is key because obviously when you think about, I don't know, Save the Children, Plan International, it is obvious that you will think that they will interact with children and they might be aware of problems. Actually, they have child safeguarding policies and procedures. But when it comes to a online or telephone company, internet company, when it comes to a bank, when it comes to a cinema chain, when it comes to hotels, well, these organizations also interact with children. It's not the main field of their services, but they might impact positively or negatively, and there might be abuses in the context of the provision of their services. And so this is the idea that you have a policy allows you to see these things you might be not aware in the first place. Then people need to understand what it is to safeguard children. You need to have a safeguarding focal point, but again, it's not the problem of the focal point, it's everybody's problem and concern. Specific procedures that you know where they are, you can see on the web page, you know where to read them, easy access to procedures of complaint that are child-friendly, so children might understand what this means, when they can use them, what it implies, consequences, accountability. Each organization with a child safeguarding policy needs to tell you what has happened the last year. Have they received any complaints or not? Of which sort? Who people trained on this or not? Are they aware? It's part of the process of the way you can see the organization monitoring and monitor your work. Children's rights, as I said at the beginning, it's not the same to protect children, that protect children who have a voice to say how they feel about their rights and what they want and what the views take into place. Also protect them while you're not interfering with their private life, their dignity, the right to not be discriminated. So when you have a rights approach to safeguard it, that puts you more pressure to have more complex and sophisticated policies and procedures in place. And what I mentioned at the beginning about more vulnerable groups. Some children experience or they are exposed to the risk of being harmed with more intensity than others. More children who come from an indigenous background are incarcerated in the world than non-indigenous children. Boys can also be sexually abused, but more girls are sexually abused, or at least we have information about that in more detail about how girls have been abused, certain specific forms of bullying, etc. What has been some examples of these emerging practices? And I just want to give a few brief examples. There are two sort of examples emerging. One is countries that have moved towards providing legal standards on child safeguarding. I'm speaking now here in England, and I'm happy that it's a country that is very much aware about this, about safeguarding. It's not something alien. It's something that is very much enshrined in the way the protection of children's rights are conceived legally and institutionally, and that is very important. As you can see, England, Ireland, New Zealand, just to give some example, Australia are much, I would say, institutionally aware about this. Why this is important? Because, for example, in Latin America, you say safeguarding, it is like saying a word in Mandarin. People basically don't understand what you're saying because we don't use the idea of safeguarding. We have talked about child protection, and child protection is only one part, one component of child safeguarding. Child safeguarding allows you to prevent, to think through the whole process of interactions, including child protection procedures and responses. But it's more comprehensive, and this, I think, is an enormous contribution to the field of child law. And reactions to this is very mixed. Some human rights activists don't like this and say, no, child safeguarding is too self-regulatory, it's not normatively grounded, we need a treaty with human rights obligations, and so we can enforce these obligations. And I agree that we need normative standards, but I think we need to think out of the box in terms of innovation and how we think the way organizations interact and how we conceive their responsibilities, even if it's not formally framed statutorily or in a law. But these are good examples. And there are other fields for example, health and education, where you can see guidelines. For example, in health safeguarding policies, risk management flags, policies in hospitals, rapid assessment checklist, for example, when a children comes into interacting with a health personnel. In education, there are various practical guides, statutory guidance on how schools should conceive education, how should prevent forms of violence in school, respond to them, etc. But there are also self-regulatory practices in many fields. We can see this thing. So this comes from international and regional organizations, non-governmental organizations, sports, travel and tourism, social media, religious organizations, thank to God, finally, and investment and development. For example, international organizations, even if the UN has been very harshly criticized for not doing enough about safeguarding, there has been some developments, for example, mostly in the field of peace operations. You know, peace operations actually engage in cases of violence against children, sexual abuse and exploitation. This is a very sensitive area of the way UN interacts with children. So there are more standards and specific guides in this field nowadays. Standards of conduct. For example, if I do consultancy for the UN, I have to sign my contract, and my contract forces me to comply with certain standards of conduct in relation to children. And agencies, some agencies, for example, UNICEF, among others, have their own specific child safeguarding policies internal to the organization, and this helps to build a more stronger awareness about this. And at the regional level as well, ASEAN, for example, the regional plan of action on the elimination of violence against children, asks governments to develop child safeguarding policies and standards. And the Council of Europe strategy for the rights of the child, and actually the Council of Europe, the Committee of Ministers of the Council of Europe has also issued some specific safeguarding standards and guidelines when it comes to projects where they might be engaging children or working with them. Non-governmental organizations, there are various examples. I just provide a list of very well-known and non-for-profit organizations working in the field of child protection. This is very much, I would say, has matured a lot, but mainly, and this is some criticism, it might be clear at the level of headquarters of many organizations, but if you go to local level, this might be not as clear that everybody knows about safeguarding. There's implementation about this, and local NGOs in many countries don't know, actually, they should be thinking about child safeguarding. They might have protocols, they might notify if they receive a case to the prosecutor's office, but not necessarily they come with child safeguarding policies and procedures. In terms of sports, we have been a lot of developments lately, positive developments in my view. The International Olympic Committee, for example, has developed specific guidance standards when it comes to this to enhance the security of athletes, procedures for submitting complaints, respond to allegations, training awareness of athletes, which have been very structurally exposed to sexual abuse in the past. And we have been aware about this in the last years. In different fields of sports. And the Federation of International Football, the FIFA, who doesn't have particularly a very good reputation, has in the last couple of years developed particular guidance and standards on child safeguarding in the field of football. And some national football associations have been also developing certain specific standards on this. Travel and tourism might be the most maybe a business sector that is maybe much more aware about sexual abuse and exploitation. And there's a very effective instrument, in my view, which is the Code of Conduct for the Protection of Children from Sexual Exploitation in Travel and Tourism, known as the Code. And the Code has a very interesting mechanism of monitoring. When states decide to join the Code, they need to report once a year about the developments on the implementation of the Code of Conduct, what they have done, and there's a review of what they have done throughout the year. And this allows the sector to provide specific procedures and guidelines. So it is not, I don't know if this has happened to you, but some hotel chains, when you get to the hotel, they have very clear rules about who might check in into the hotel. This is part of the safeguarding policies. That an adult cannot enter with a child without showing that there's a family relation there. There's the responsible adult or legal details like that. There's also voluntary and mandatory national codes of conduct. The code calls states to develop these codes of conduct, and we have many states that have codes of conduct. Most of them are voluntary, not mandatory codes of conduct, meaning the sector provides these codes of conduct, and if you're a member of the Chamber of Travel and Tourism of that country, you are obliged by that code of conduct. But not all of them are mandatory as established by law. And individual policies, I was mentioning, hotel chains, and even the Cruise Lines International Association has specific safeguarding policies and procedures. Then social media, I mentioned this before. There has been some developments and standards in the context of Europe, particularly. The Council of Europe has developed a specific guidance on this, on children and protection of their rights in the context of social media. There are also self-regulatory practices based on community rules. And I would say that TikTok and Twitter are particularly interesting because their community rules force their organization to report the cases of suspicious cases of child pornography, of child sexual abuse and exploitation to enforcing authorities. And this allows to have a register of how many cases have been flagged throughout the year. And this might allow, for example, Interpol or other institutions from the police side to engage and react to these flags that have been raised in their software. The power of these platforms is immense, and also the power of providing information to identify the groups of exploitation and practices of exploitation online, or other forms of violence. We can know, for example, how many cases of bullying, or if children have reported bullying in TikTok. These platforms provide that information. So maintaining the privacy of children who have suffered this, you can use data to have a better understanding of violence online. Religious organizations, there are more examples, but I'm just bringing these two. They're different in terms of nature. The Church of England, actually, the safeguarding policy of the Church of England says that safeguarding is at the core of Christian values for the Church of England. This is an express declaration of the Church of England. And the safeguarding policy of the Church is very clear in providing a set of rules, procedures, people who are responsible for developing procedures and responding to allegations. And this is extremely important, as you know, for the history of sexual abuse from religious institutions. In the case of Catholic Church, it's a whole different world. For two reasons. First of all, because the Catholic Church is a party to the UN Convention on the Rights of the Child. That means that it has officially and formally obliged itself to this international treaty. And this means that it has a very specific status of international legal obligations. It's not as any other church. It's a subject that is under these obligations as a party of the treaty. And the Catholic Church in the last maybe 3 years or 4 years has developed various changes in providing child safeguarding policies, actually reforms to the canonic code. For example, under the canonic code, you were able to burn antecedents of a religious offender. After 30 years or 40 years, I just don't remember the specific years, you were allowed to burn those records. So meaning that there was no history about this. Imagine this in terms of historical memory, statute of limitations. It was the very, very complicated rules that some of them have been reformed lately in the canonic code to try to take away some barriers and very incorrect practices and standards, I think, for that. And some congregations as well. some specific obligations. The Jesuits or others, for example, have developed specific child safeguard policies. In terms of investment and development, I think this is also interesting. When you have money and you want to invest it somewhere, you go and ask, well, where my money will give me returns, no? It's capital, you want to make it work, your money, funds, where you invest. Well, it is important to know that with that money, things can be done, and not only positive things, and not only in terms of the environment or social risk, but also in terms of, as an examples I gave at the beginning, that money could be used by people who actually, in the context of investments, engage in human rights violations of children. So, for example, there is one example I just shared with you, the Investor Alliance for Human Rights. It's based in New York. It moves $5 trillion per year in investments, and the alliance allows investors to provide them with security about where that money goes, and that investments pass a certain filter in terms of the impact of those investments in protection of human rights in general, or other negative impacts of investments abroad. Also, global and regional multilateral development banks or agencies of cooperation are thinking about this. For example, in Australia, the International Agency of Cooperation, which works very strongly with Asia in general, is much aware about, for example, child sexual abuse and exploitation online, or that sexual predators from Australia might be going to these places to exploit children, and physically or online. So that means that all the investments in terms of international corporations must be aware about this, and international agencies of cooperation are starting to develop certain standards in terms of child safeguarding, and also international banks develop. Sometimes they refer very loosely to this, for example, social risks or environment impact, in the case of the World Bank. Nothing specific in the field of children, something more in the field of gender, but women, but not something specific in the field of children. But the Council of Europe Development Bank, as one of the formal declarations, it's obliged by the human rights obligations and principles of the Council of Europe. And this obviously also encompasses the protection of children's rights under the European Convention on Fundamental Rights. And the Asian Development Bank also has some general rules of impact of investments that, in my view, could allow to develop more specific policies and principles or procedures in the field of child safeguarding. Now, as a third point, how we see this emerging trend in child safeguarding, what is the relationship with international human rights law in general? You know, and everybody that studied international human rights law know this, that states have three types of obligations when it comes to protection of human rights. They have to respect human rights, meaning that they don't have to directly violate rights. It's a negative obligation of not violating the rights of someone. That means that a police, a judge, a migration officer, a public school, they cannot violate directly the rights of children, because that will go against their obligations to respect the rights of the child. But secondly, states have an obligation to protect the rights of the child. And this is a positive obligation, meaning that the state has to be aware that they need to regulate and respond to violations of the rights of the child that take place in the private sphere. So, for example, if a parent abuses a child, well, the state cannot say, well, I didn't do it, it was the parent. There's an obligation of the state to protect children and to create laws, norms, and procedures that prevent abuse and exploitation and respond effectively to those. But this could be also by private actors. If companies or non-profit organizations are committing violations of human rights, well, the state is responsible in last instance to prevent those violations and respond, provide remedies, for example, effective and just remedies to respond to those allegations and to protect the rights of the child. And the third, which is more complicated, I guess, it has created a lot of debates in the field of international human rights law is the obligation to fulfill. And this is the idea that the state has to guarantee that rights are exercised de facto. Not only do you have formal rights, you are a child, so well, you have a right to be free from violence. Well, but if I don't have a legal representation, I cannot go to the court and I cannot defend myself because I don't have the money, well, then your rights is not fulfilled. Your right to access to justice is not effectively fulfilled. You just have a formal right, but you cannot exercise. What happens is that when we had a state that was doing most of the stuff that is related with the life of children, health, education, transport, everything, well, you basically were working around these lines with a very clear subject of these obligations. But when you outsource this, when you say, well, now transport is done by private companies. A friend, Jimena, just came here today from London. She took the train, Great Western Railway, I think, Great Western Railway, I guess. Well, that's a private company. Well, but children might get into that train, right? Children might be stole or abused in that train. But what's the child safeguarding policy of that railway company? What happens in railway stations? What happens when they interact with the personnel of the company? All these questions, it makes you think, well, before it was very clear, it was the railway minister, I don't know, no? the public office that we're dealing with this. But now, when everything is, a lot of things are privatized, states cannot, and the Committee on the Rights of the Child has been very clear about this. The Supreme Court of Canada has been very clear about this, and other organizations, the European Court of Human Rights has been very clear that private actors, when they are performing public functions, the state retains its obligations, direct obligations to prevent that violations to the rights of the child take place, but also that these private actors effectively fulfill the obligation that was initially under the core of responsibilities of the state. So this creates a lot of challenges. It's not just a regulator. This is what I want to say. State is not only a referee. No? They, well, no, don't do this. I just provide the rules. Very market-wise approach to human rights. The state has a more active role based on its international obligations. It has a right to fulfill the rights of children, and this requires states to engage more directly in understanding what is happening in the field in the private sphere in order to secure the rights of the child while protecting the rights of the child and protecting the right of others. So this is the challenge. You have to do it in a proportional way, reasonable way, but this is, I would say, the normative challenge. When it comes to the private sector in particular, the business sector, international law and international practices have developed specific standards that apply to the business sector in general for human rights, but some of them more particularly for children's rights. And as, for example, if you see the children's rights and business principles developed by UNICEF, you see a set of specific guidelines to business and companies, the business sector, that require their responsibility to respect. So private actors, businesses, transnational corporations, and other business activities cannot directly violate the rights of the child. It's a negative obligation, but it also has a commitment to support. This is the way it's framed. It may be more loosely, it's a commitment to support. It's not the same that fulfill. It's not the same to protect, but there's an emerging trend I see to try to be aware that these private actors actually engage very substantially with children. In practice, they are the ones that are fulfilling access to various public functions and services, and that's why they need to respect and support the protection of the rights of the child while interacting with children. And obviously, based on that, comes human rights due diligence, monitoring, child safeguarding policies and procedures. It's a lot that it comes with this general principle. And only a very minor portion of business activities, companies and transnational companies in the world do this. If you see, for example, some of the data in terms of records of human rights compliance in the world, you see that there are an enormous amount of space in the market where very important transnational corporations, bank, or financial services just don't have human rights due diligence. In general, less child safeguarding policies and practices. And states need to be aware that it's not only bad luck, but it's not only to go to a conference and say, well, we'll see good practices and we will applaud these good practices. And we will give you an award for being such a cool organization that you have this amazing new child safeguarding policy. That is good. I'm a positive person. I believe that we have to engage people on this and we have to congratulate institutions on this. But it's not only that they are very nice, they are obliged to do so. And states are obliged to tell them that they are obliged to do so. But if states continue just looking at child protection organizations and not looking at the big picture of interactions of children organizations, then we're losing the effective protection of the rights of the child beyond the protected and comfort-filled interactions in child protection. So some general conclusions out of this, and what is this about this polycentric? It's just that I love the word, first of all, the Greek word. My grandmother, Panayota, was Greek. I love Greek words in general. But the first thing I want to say is that it's this, based on this tour, common duties and responsibilities are a key component to understand the protection of the rights of the child. It's not only states. This is not Geneva in New York. That's it. And the report of the state. No, the clear idea, I guess, of the development of the field of child law is that all actors, public and private, have duties and responsibilities when it comes to protecting and respecting the rights of the child. Obviously, we need to make legal distinctions. What is a responsibility, a legal obligation, a duty, etc. No? But this is the general principle. Second, in my view, we need a functional approach to human rights obligations. What this mean? That normally when you, for example, if you study international law traditionally, you will know that subjects of international law are states, mainly. No? So the idea that you are recognized as a subject of international law is that you have certain characteristics. You have territory, you exercise effective jurisdiction. That's what you teach normally in international public law. Well, actually, that's a way to see who is a subject of international law. There's another way to see it, which I think is more in line with what we see in practice, which is to have a functional approach to understand who is a subject of international law. This is based on the capacity of an organization to create norms, to implement them, and to be a part of international relations. And this is what happens with big transnational corporations. It's not just a company. No? Davos is not just another meeting. It is something there that is happening, that is creating the way we normatively understand relations, de facto. No? It's not the General Assembly, it's not the Council of Europe, it's not the Organization of American States, General Assembly, but it's creating law. And this functional approach, which actually international law has some academic background, it's not just my invention, it's based on this idea of the capacity of organizations to be a subject, and not this general considerations of that we normally associate with states only. Obviously, this creates other challenges. Once you said that you have obligations, but you have rights. And so you start creating law, and maybe in the General Assembly, should we have a transnational corporation sat in New York as well? Because if I have an obligation, I can have a right also to write the next treaty, right? Well, they create a lot of challenges in this area. I will not touch to this now. Then I think this way to conceive a polycentric approach to human rights obligations, meaning that all different organizations have obligations when it comes to children's rights, provides a more horizontal integration to understand the way international relations take place and the way international human rights law operates in practice. I have to say this after almost 25 years working in international human rights law. Really, what happens in the world is 30% states or 40% states and 60 or 50% what happens from the private sector. This is what is happening. So I think we need to think out of the box in terms of what we create in terms of norms, procedures, practice, and how we engage the way different organizations, both public and private, shape the life of children and human rights in general. And finally, obviously, this creates some challenges, as I said at the beginning. Once you say, well, safeguarding is good, private organizations need to, they are creating these new standards, well, we need to think how we relate with these private organizations. And I think we are ill-equipped to do this. We want to have norms, standards, and we keep that in one side, and then we think about law and institutions and the justice system and international law in a very fragmented way from the practices and interactions that take place in the public sector, for non-for-profit and for-profit. And I think this safeguarding, for me at least, has made me think a lot about how you engage this discussion, which is discussion of business and human rights, private actors and human rights, into the field of child law, and to expand our concerns from only child protection to the effective prevention and response to safeguard the rights of the child. Thanks very much.
So, questions to Nico?
Hi, I'm Emma, and I'm doing a Master's in Public Policy at the moment at the Vatnik, and I'm from South Africa. So my question is about how do we ensure child safeguarding is a topic of conversation in contexts where basic rights aren't being kind of achieved. So like if I think about an example in South Africa of in a child care center where kids are orphaned and they're like nutritional, they're not being fed properly, they're not being cared for properly, like their very basic rights aren't being achieved. Like how do we bring the concept of child safeguarding into that kind of bleak looking environment? And do you think that, I understand like there's so much space in terms of like TikTok, and I've been like a part of like applications of when I'm evaluating kids, and there's great kind of like tech ways and organizations that like you go through processes as, oh, now you are certified as a great child safeguarder. But from a very basic level, how do we ensure that that's reaching the grassroots level?
Yeah, well, it's an excellent question. I don't have a clear answer for that, but I would say two things. First of all, this is the challenge of human rights in general. The structural inequalities, institutional inequalities that allow you to talk about human rights in general. You come from South Africa, you come from Chile, Latin America. I mean, some people would say, why are you wasting your time talking about child safeguarding? Well, there's a widespread institutional violence taking place in the streets or in other settings, or lack of access to social and economic rights. And I do agree with that. But secondly, I would say that that's why the idea is to have this polycentric approach to human rights, meaning that it's fine, you need to continue working in the way, for example, states comply with their full obligations of respect and protect. But in practice, even in South Africa, many aspects of the lives of children are being outsourced, are not done by the South African government, they are done by private actors. And if we don't have this holistic view about which organizations interact with children and how we fit different obligations and duties in different levels in this puzzle, then I think we are missing the idea of integral protection of the rights of the child. And I think there's also, it's not your question, but I think there's also some skepticism about this. When I read about this, like, yeah, it's another arm of international capitalism that is trying, to clean a little bit the image and having this very interesting things, but in practice, it's not the same. So that's why I agree that while innovation is important, because when organizations evolve, they evolve ethically as well. It's not only just to have a good service, a good product. You can evolve ethically as an organization, even if you're in the market. That can take place, and actually that has happened in certain organizations. And we know that when you have to work in an organization, how's the environment, how they treat people, what's their gender policy, this is important. But this doesn't take out the idea that while this is happening and it's good, a state needs to govern that process as well, or attempt to govern it to the extent possible. And that brings to the normative dimensions of this, locally and internationally. Locally, we have some examples, but this is very a la carte, very boutique examples that take place in certain countries. And globally, there's not much about this. And I think we could do much more as human rights activists to bring this also into the normative field, while being aware that not everything is normative, and that it's good to have partners in the private sector, for-profit and non-for-profit, to innovate in terms of organizational evolution.
At one point you mentioned that there's some kind of role for kind of involving children in this, sort of listening to children's views on these things. Could you elaborate a little on that, and possibly on a potential tension with this and the idea that children are not yet sort of fully responsible agents, or maybe in some sense their words aren't kind of authoritative in the way we take adults to be?
Absolutely, it's an excellent question, and I will just give you something that happened to me a couple of weeks ago. I was discussing with a foundation that worked with children with mental disabilities, physical and mental disabilities, and they were trying to have a new policy and procedure to prevent violations of rights of children, because they are in institutions, no? So they have care systems. The children who don't have family connections are left, basically, no? So they are in institutions because there are not many alternatives so far. And so when I read this, which I was very happily impressed of all the work they have put into this, they have been very harshly criticized, because if you have an institution, you are criticized just by having an institution, even if you're doing the best to try not to. And so it's fair and unfair at the same time. I think we have to be more reasonable about this, but never mind. They have something about sexual and reproductive rights. No? So, for example, integral sexual education. How you will deal with your sexual and reproductive rights when you're a child and when you have a mental disability. So that's a huge question. And but the way they were doing it, they didn't know what anyone thinks in the institution about this. I've never asked any children within the institution what they think about this. Maybe someone talking to another knew something, but there has not been any kind of exercise of trying to understand how they feel about this. How, for example, they relate their feelings and emotions with their sexual life, which is a key component of integral sexual education. If you don't engage children, if you don't listen to what they're saying, hardly anything will happen. And let me give another example. I was in a seminar here in the law school a couple of weeks ago, and we were talking about access to justice for children. And, you know, as lawyers, we talk about access to justice, we talk about adjudication, legal representation, legal aid, very lawyery things when it comes to access to justice. And I was asking the students, well, do you know what children in the UK, or in England in particular, think about the justice system? How they feel when they go to a court? What do they think about judges, personal? Where's that information? You need to create that information, because from that information, you can make organizational corrections in proceedings, in practices, in cultural stereotypes that you might have, that children cannot talk about this, or they might talk about that, or that if you're a Roma children, well, you are more vulnerable just because you're Roma, and that's it. You see, or because you're a migrant, and depends where you're coming from. All these things, I think for organizations, it's not that they will be solved by hearing children and taking into account their views, but once you start listening to children and bringing those views into your diagnosis first, and then in the review of your programs, procedures, and practices, you really are more right on spot on what you have to do in terms of interactions. We are used to ask to people we love or we care, what do they think about our relations? Well, organizations need to start asking children what do they think, what children think about those interactions, because they are actually in those relations. They are living in those relations. They are affected, impacted by those relations. So I think that's, I don't know if I explained myself well, but I think I was having that in mind. Thank you. Else?
Could I ask you,
Yeah, sure.
one of your early points on your slides was about equality. And you also talked about especially vulnerable groups. There seems to be a tension there in terms of or possible tension, in terms of the strategy of implementing the safeguarding of children's rights. Is that a real problem or not?
But it's an apparent problem, I think. In the sense that the way, obviously, when you think in terms of providing equal access to safety, to feel safe from the risk of harm and abuse, I think that you need to standardize those levels of protection. In that sense, it's a neutral, standardized approach. And if you think about certain group of children, it might become problematic in the sense I think you're asking. But the principle of equality is not the same as equal treatment. And the principle of equality might force you sometimes go with equal treatment, or in other occasions to go with a differentiated special treatment, which is a derivation from the principle of equal respect and concern. So people might experience risks, or might experience, for example, lack of access to education or health differently because they are coming from a specific migration background, for example, because their parents are coming from a certain country, and this might impact the interactions with health services. Or, for example, if there's a child that is a transgender child, it might experience protection from bullying in neutral practices within the school differently from children who are non-transgender. So I think that the principle of equality forces you to pay attention to, based on an analysis, of when you have to provide equal treatment in terms of safeguarding, and when you need to reinforce those protection by special measures of protection based on the concrete position in which that child is placed. And I will, just to finish this, where the child is placed in his or her environment is placed. Actually, the Convention on the Rights of the Child, the rights to equality and non-discrimination is very interesting because it provides protection for children not to be discriminated on grounds of sex, gender, race, etc. of the child or of his or her family or responsible adults. Because children are so intertwined with these adults that if your parents are discriminated, or your parents will be, for example, subject to a migration proceeding, which might imply that they will be sent back to their country, well, you will be impacting the right of children to a family life and not to be separated from their parents. So equality requires a more complex factual analysis, and this might allow you sometimes to make distinctions and not to treat equally, but complying at the same time with the principle of equality before the law.
Thank you. We've come up to the hour, I think, so it's time to give you a break.
Yeah, thanks very much.
If I could express my thanks on behalf of all the people here, but also those who've been listening online. It's a great privilege to hear a true expert expound on a subject. And I think you've given us a wonderful overview, but also, not least in your answers to questions, you've elaborated and made it even more specific and given us an idea of how these principles can be translated into practice. And I think this is especially appropriate in a college where family law and human rights law are strong specialties. So these are issues that are of great concern to this college and, of course, more generally to the university and indeed to everyone. So thank you very much indeed for a really educational experience.
Thanks, Ray. Thanks very much. Thank you very much.